The Tenant Emancipation Law. Presidential Decree No. 27, or the Tenant Emancipation Law, was signed by President Marcos on October 21, 1972. It supplements the comprehensive agrarian law and applies only on private agricultural land devoted to rice and corn under share tenancy or lease tenancy. It gives the tenant the right to lawfully own or be a deemed owner of 5 hectares of the land if it is not irrigated and 3 hectares if irrigated. In all cases, the landowner may retain an area of not more than 7 hectares of the land he owns. The Tenant Emancipation Law doesn't mean an automatic transfer of ownership to the beneficiary or the tenant farmers. The tenant will have to pay in full or in amortization of the land for the period of 15 years. No title of the land owned by the tenant farmers will be issued until full payment of the land. In case of default, the amortization due will be paid by the cooperative in which the defaulting tenant farmer is a member, with the cooperative having a right recourse against him. The land transfer of the presidential decree is affected by 2 stages, which are the issuance of certificate of land transfer to the farmer beneficiary and the issuance of the emancipation patent. The certificate of land transfer refers to the qualification of the tenant farmers to possess the land and comply certain conditions preparatory to ownership of the land. Emancipation patent refers to the farmer beneficiary's absolute ownership over the landholding and conclusive or undeniable authority for the issuance of an original or transfer certificate of title to his name. The emancipation of patent can be or may be cancelled on the following grounds: abandonment of the land, neglect or misuse of the land, failure to pay 3 annual amortizations, misuse or diversion of financial and support services, sale, transfer of conveyance of the right to use land, illegal conversion of the land. The Tenant Emancipation Law does not merely state the benefits of the tenant farmers, but also states the payment and just compensation of the landowners. The just compensation payable to the landowners through any of the payable modes at the option of the landowner. First, the direct payment to the landowner by the tenant in cash or in kind by mutual agreement of both the tenant and the landowner, and subject to the approval of the Department of Agrarian Reform. Second, payment through the land bank with 10% payable cash and the balance payable to land bank bond over a 10-year period. And third, the other modes of payment that may be prescribed or approved by the Agrarian Reform Council.
Jurisdiction over cancellation of EPs. All cases involving the cancellation of registered emancipation patents are within the exclusive and original jurisdiction of the Secretary of the Department of Agrarian Reform. The tenant beneficiary cannot sell or transfer ownership of the land acquired under the Tenant Emancipation Law, except for the government or by hereditary succession. The tenant farmer will pay the land bank. The farmer beneficiary or his heirs will pay the land bank the total cost of the land plus interest at the rate of 6% per annum for 20 years in 20 equal annual amortizations. The emancipation patent will be issued to the farmer beneficiary after the full payment of the amortizations. What if the farmer beneficiary failed to pay the land? Failure on the part of the farmer beneficiary to pay the 3 annual amortization shall cause the land bank to foreclose the mortgage. But the tenant farmer may lift the foreclosure. The tenant farmer may lift the foreclosure made by the land bank within a period of 2 years from its registration, paying the land bank all unpaid amortization on the land, interest thereon of 6% per annum. If the tenant farmer or any of his compulsory heirs does not take steps to lift the foreclosure within the 2 years period allotted time, owners of the land will be transferred to the land bank. Thereafter, after 3 months of foreclosure, the land shall be sold to any interested farmer duly certified to as a bona fide landless farmer by the Department of Agrarian Reform of the barangay or the 2 closest barangay where the land is situated. Retention right of the landowner. The landowner is entitled to retain an area of not more than 7 hectares. Personal cultivation by the landowner is not required as long as it can be done indirectly through labor administration. Thank you for listening, and may God bless us all.